Hi everybody, Dave Sugden. Today we are going to talk about depositions. Specifically, we're going to look at the issue of whether we ever want to ask our own client questions at deposition. And the conventional, or at least the common answer in most cases, is no. Why do we want to spoon feed our opponent information that he or she should have asked but didn't ask? Or why should we clear up misunderstandings and foreshadow things that can happen in trial? But is there ever a reason to do so? And to look at that issue, we're going to look at the recent case from 2019 of Berroteran versus Superior Court. And what we're going to specifically look at is the former testimony exception to the hearsay rule. And so what is that rule? So again, we are talking about hearsay evidence. And this is the framework we're always looking at when it comes to evidence questions at trial. And so we first look at relevance, then foundation, and then we get to hearsay. And as we've looked at in other videos, there are a lot of exceptions to the hearsay rule. And when we think about the exceptions, we want to quickly think of what are the main categories of the exceptions. And what we have here are sort of ways to think about all of the exceptions to the hearsay rule in broad categories. And so the first exception are party admissions. Anything a party has said, that's going to be in as an exception to the hearsay rule or as non-hearsay in the federal rule. And here we have prior statements, writings. These are the documents that may fall under exceptions to the hearsay rule, and then historical things, old records, boundary lines, things like that. And today we're focusing on prior statements, specifically prior testimony. And in California, prior testimony can be defined as these four categories. And specifically, we're talking about California Evidence Code section 1290, and it defines what is former testimony. And it talks about testimony that takes place in another action, which we'll be talking about today. It also talks about testimony in a prior hearing or a prior trial in the actual case that's being litigated, depositions, which we'll talk about today, as well as prior testimony in an arbitration, so long as the arbitration has a verbatim transcript. So then, what is the rule with respect to former testimony? And here we're going to look at California Evidence Code section 1291. And again, this is an exception to the hearsay rule, and it basically says this is one of the exceptions when it comes to former testimony where the party that the testimony is having offered against was a party to the prior action. And it says these statements can be admitted if the declarant is unavailable and the statement was either offered by that party, in other words, the lawyer for the party elicited the testimony of the declarant, or what we'll talk about in this case is it was offered against the party. This is something where the testimony was elicited from the declarant by the adverse lawyer. And this can be admitted against the party in the present case if we have the following. The party in the prior case had the right and opportunity to cross-examine the declarant, and this is the key language that was examined in the Berroteran case, is did the party have the same interest and motive to cross-examine the declarant? And that brings us to the Berroteran versus Superior Court case. So what's this case about? We have a plaintiff, Mr. Berroteran, and he brought a lawsuit against Ford. And very generally, the allegations was that I bought this Ford truck and the engine was defective. And I relied on all of Ford's representations to say this was a great truck. I bought it, it wasn't very good, I would try to have it repaired, and they did a bad job repairing it, and so I'm going to bring this lawsuit under a number of consumer protection statutes. Mr. Berroteran was not alone when he brought his case. In fact, he was part originally of a putative class action where the same allegations were brought against Ford, not just in one class action, but multiple class actions. It ended up being this multi-district litigation against Ford. And the case ultimately settled, but before it settled, there were 9 Ford employees and former employees who sat for deposition. And they were in deposition being examined by the plaintiff lawyers, and they were defended by the Ford lawyers. And the issues that were asked in these depositions all had to do with the same claims that Mr. Berroteran was alleging in his individual case. And so these were questions about the allegedly defective motor, or the allegedly defective repairs, etc. And so in the multi-district litigation, these folks were deposed and the case ultimately settled. And Mr. Berroteran opted out of the settlement and said, no, I don't want to be part of this class action settlement. I'm going to bring my own lawsuit. And when he brings his own lawsuit, he's getting ready for trial. And these 9 Ford employees and former employees aren't available. And Mr. Berroteran says, no problem. Under the former testimony exception under Section 1291, I'll just have their deposition transcripts read to the jury. And Ford said no. They filed a motion in limine saying that, well, this was a deposition, and so this is hearsay. And because it's a deposition, we had a much different interest and motive to cross-examine these people, and so therefore you can't allow this testimony to be allowed. And in fact, the trial court granted Ford's motion in limine, and what the trial court did in Berroteran is it cited the case of Walgren versus Coleco. And what Walgren said is a deposition is a much different animal than testimony in trial. And a deposition is essentially a discovery tool. And so when a party is being examined in deposition, there's not the same interest and motive to cross-examine your own client. And so therefore, because there's a different interest and motive, it doesn't fall under the former testimony exception under Section 1291. And we see in 2019 the Berroteran court disagreeing. And what the Berroteran court did is essentially say, we disagree with Walgren because the issues that were examined in this case were the exact same issues as what Mr. Berroteran was facing in the individual case. And it looked at a bunch of other federal cases where the similar issue was examined and said, look, in the modern era with video depositions, with multi-state litigation, depositions in trial, the interest and motivation is pretty similar. And so therefore, we reject this per se rule from Walgren that depositions are different. And so therefore, it held that we are going to consider this testimony as former testimony under Section 1291, and so all of these deposition transcripts or videos can be played during Mr. Berroteran's case in chief. That's the holding. One thing I do want to point out is it seems as though the Berroteran court could have come to the same or correct conclusion in an easier way. Because if you look again at the Walgren case, it tried to essentially carve out a per se rule for depositions, where it said, look, the motivation of a party in a deposition is fundamentally different from trial. The problem with that is that it essentially carved out a judicial exception where there's not such an exception in the evidence code. The evidence code specifically says under Section 1290 that when we talk about what is prior testimony, deposition are among the things that the statute contemplates. And so long as this is among the things that are considered as former testimony, so long as there's a similar interest and motive, this can be admissible under the Section 1291 exception for former testimony in the hearsay rule. So that is Berroteran. It provides some insight as to when we may want to examine our own clients at trial. Thanks for listening. Again, I would encourage you, if you found this helpful, to look at evidenceattrial.com. We have other videos. We also have upcoming live events and online classes where we do a deep dive on these rules of evidence. Thank you for watching.